How I fight these tickets is it's a purely technical defense. I'm not arguing that you were or were not speeding, because the way the law is written, as long as you're traveling above the posted speed limit, for example, 75 miles per hour in a 55 mile per hour zone, then technically you're guilty of speeding. Then it just becomes a matter of how many points you're going to get on your driving record, what the prepayable fine amount is, and if you live out of state, how it's reported out of state. And if you remember back to your government classes, back in elementary or middle school, there are two different types of law. There's statutory law, which is what you're charged with, 21-801.1 of the Transportation Article of the Maryland Code, the speeding statute. That's law that's created by the legislature and signed by the governor. Then there's what's called case law or judicial law, and that's law that's created by the courts of appeal, either here in the state of Maryland or federally. An example of that would be like your Miranda rights, where you have the right to remain silent. Anything you say can be used against you in a court of law. Well, in Maryland, we have two cases dealing specifically with speed, and what they do is they outline what foundational evidence needs to be introduced prior to the speed coming in. Now, this is evidence beyond identifying you as the driver, the proper vehicle, and the events occurred in the county in which you're charged. For example, Howard County or Baltimore County. And in Maryland, the two cases dealing specifically with speed, they outline 5 things that the officer has to testify to prior to the speed coming in. That is, that he was certified to operate the equipment he was using, the equipment itself was certified, the equipment was tested before and after the stop and found to be in proper working order. And before and after the stop can mean before and after the officer's shift and periodically throughout the shift. That proper procedures were followed in operating the equipment and that proper records are maintained. Now, as long as the officer or trooper goes through those 5 things, much like I just did, then he's laid what's called the proper prima facie foundation. That's just Latin legal speak for on the face of it. The great thing for me as a defense attorney is that's a rebuttable presumption, meaning we can fight it. And how I do that is I issue what's called a subpoena ducis tecum. Again, more Latin legal speak for a subpoena for documents. Now, in Maryland, we have very strict rules as to what we're allowed to ask for before court and what we're allowed to have access to. There are a lot of internet websites that give you the answer on how to fight a ticket, and they guarantee this is how you can beat your ticket. Well, in every one of those that I've seen, they won't work in Maryland because they have assumptions that aren't available to us here in Maryland, like discovery. So by issuing that subpoena, I'm requiring that that officer bring all that documentation to work, and only an experienced attorney will know what to look for in those documents and what documents they're supposed to have. And if the officer does not bring those documents to court, or if they're brought to court and they don't have the proper certification, and that sounds kind of circular there, but the certifications need a certification. If they don't have that proper certification, then it's like they don't exist. They can't come in. So there are lots of different technical steps to the state's case. And if we can show the court that the officer didn't operate the equipment according to his training, if they're missing some documents, or in some cases that I have recently, that the documents show a glaring error, then we can keep the speed out. If they don't have the speed, then we get a not guilty.